Okay, thanks everybody. We'll go ahead and get started. Thanks for joining us for this webinar on key developments impacting corporate executives in the winter of 2020 and 2021. My name is Lauren Briggerman, and I'm a member in the litigation department at Miller and Chevalier with a particular focus on white collar.
My name is Katherine Pappas. I'm counsel in Miller and Chevalier's litigation department, and I also focus on white collar work.
And hi, I'm Ian Herbert. I'm also counsel in Miller and Chevalier's white collar criminal defense and investigations group.
Okay, so I'm going to give you a brief overview of what we're going to talk about today. First, Katherine is going to give an update on the impact COVID-19 has had on court proceedings, both on whether or not courts are generally open, as well as whether or not jury trials are proceeding. I'm going to then talk about some recent trends in cartel enforcement, in particular focusing on cases in the labor market, as well as some other domestic investigations that are continuing to result in charges. Then we're going to send it back to Katherine, who's going to focus on some domestic investigations, as well as some updates in FCPA. And then finally, Ian is going to talk about significant developments in financial crime enforcement. He's been focusing a lot lately on the anti-money laundering provisions of the Ndaa, which are really important for companies and executives to keep in mind. And so he'll round it out with a discussion of those new laws. And so first, we will turn it over to Katherine, who is going to talk about how the pandemic is affecting courts.
Thanks, Lauren. So here we are, almost a year into the pandemic, and federal courts across the country are continuing to constantly reevaluate their approaches to their operations and to pandemic safety. So while we saw many courts completely cease in-person operations starting last spring, as the summer and the fall came, courts started to open back up. And in fact, in November, the Southern District of New York had its first white-collar jury trial since the pandemic had shuttered courthouses. The jury in that matter delivered a guilty verdict to two former executives of a biopharmaceutical company who had been charged in a securities fraud-related case. And just this week, the former CEO was sentenced to 1 year in prison and ordered to pay $1 million fine for his securities fraud conviction. And the former COO, who had been convicted of conspiracy to commit securities fraud, was sentenced to 1 year in prison. So trials and sentencings are considering a pace. But as the fall turned to winter, started to move into this year, courts started backing off of their reopening plans and started to close down again. So where we stand now, to pick just a few courts from across the country, in Chicago, civil and jury trials remain suspended until March 1st, with video and teleconferencing being authorized for a number of proceedings, including criminal, pretrial, and post-conviction proceedings. The Eastern District of New York has suspended criminal and civil jury trials until March 1st. And in DC, trials are also suspended until March 14th. But with case numbers currently going down, courts are starting to ease up on restrictions again. So we saw that the Southern District of New York had suspended in-person operations through February 12th, and that date has come and gone, and we haven't seen a further extension of the suspension on those in-person operations. So we'll continue to keep an eye on it. Could be that we're going to see the same trend that we saw last year, which is more reopening as the weather gets warmer and case numbers start to go down. But amidst all of these various changes to in-person proceedings, motions practice is certainly continuing apace amid the pandemic, and judges in the Southern District of New York have continued to probe potential prosecutorial misconduct in a few cases. So folks may recall from our last webinar that following one of the last pre-pandemic white-collar jury trials in the Southern District, the U.S. Attorney's Office had dropped their sanctions case against Iranian businessman Ali Sadr Hashemi Nejad. Judge Allison Nathan had demanded detailed information from prosecutors regarding alleged Brady violations. And last fall, she issued a detailed opinion describing disclosure-related issues in the case, including a particular failure to disclose an exculpatory exhibit until trial had already begun. an error that she described as compounded by chats discovered between prosecutors discussing burying the exhibit in a larger disclosure and the ultimate production of the exhibit in an email that deliberately obscured the fact that it had not been previously produced. She emphasized that the issues that plagued the prosecution in the case called for what she called systemic solutions. So just this past week, in an opinion that was unsealed earlier this week, Judge Nathan issued a further opinion and order in the matter. She did not conclude that prosecutors had knowingly withheld exculpatory information or intentionally misrepresented facts to the court, but she did urge a full investigation by DOJ's Office of Professional Responsibility, noting her view that the actions constituted, quote, grave derelictions of prosecutorial responsibility, and referencing the systemic misconduct that had occurred in the case. Interestingly, the opinion also noted a recent disclosure by the government of further misconduct stemming from the FBI's review of raw search warrant returns provided by the Manhattan District Attorney's Office. The use of data from the DA had been the subject of suppression litigation previously at trial. But as explained by the court, the recent disclosure described the FBA's use of search warrant returns as much more systematic than it had been previously represented, involving over 600 searches of the database. Judge Nathan stated that it, quote, boggles the mind that prosecutors had not ascertained that information prior to litigating the suppression issue. And she asked whether the searches represented whether the system represented a blind spot in the government's attention to their Fourth Amendment and Brady obligations. So while she was closing out the matter on her docket, she was definitely leaving open space for further review by other institutions. And in a separate matter out of the Southern District, Judge Katherine Pappas is poised to receive briefing this spring regarding former hedge fund founder Analesh Ahuya's counsel's assertion that they had obtained potentially exculpatory material following their client's sentencing and trial through a FOIA request. Defense counsel was specifically focused in on the drafting of a plea allocution from a cooperating witness at trial. At this point, the court has required prosecutors to produce documents and also submit individual declarations regarding their involvement in plea discussions and other communications with the witness and his counsel. And she's asked for the basis for answers that the prosecutors previously provided to the court regarding the plea allocution. So the issues are going to be fully briefed by early May. So this is one that we're going to be keeping an eye on as we move forward. And with that, turning to actions against executives, Lauren, what is going on in the cartel space?
Thanks, Katherine. So let me run through several different updates on the cartel enforcement space. First, I want to focus on charges in the employment sector, and specifically the fact that the Department of Justice has brought its first criminal charges targeting collusion in the labor market. Before I give you an update on the most recent criminal charges, though, I want to walk through how DOJ has historically treated this conduct, which is actually as civil rather than criminal conduct. Up until the end of 2020, the Department of Justice has pursued anti-competitive employment practices through civil enforcement actions, and specifically DOJ has sued particular companies or entities and then entered into consent decrees with those companies. Those consent decrees would not levy a civil fine, but they would require the companies to cease the prohibited conduct and usually to employ certain compliance measures to ensure that the conduct didn't occur in the future. And even though there wasn't necessarily a civil fine, these consent decrees would often spark private civil litigation by potential victims. So I want to run through just a couple of examples of those cases that have gone on in the past couple of decades. In the 90s and early 2000s, DOJ focused on the healthcare sector in particular. In 1994, the Department of Justice sued a society of HR professionals for conspiring to exchange non-public wage information about registered nurses. And the result of the exchange of the information was that hospitals were matching each other's wages. The government in that case did not view the conduct as criminal and sued these HR agencies and ultimately entered into a consent judgment whereby the defendants were required to adopt certain compliance requirements. Then again, fast forward to 2007, another healthcare related case. The Department of Justice sued Arizona hospital associations for acting on behalf of Arizona hospitals to set a uniform bill rate schedule for temporary nurses. In that particular case, again, another consent judgment was entered into that barred the associations from setting required billing rates. Then you jump again to 2010, there was another significant case there where the Justice Department sued 6 tech companies for entering into agreements not to cold call each other's employees to solicit them. Again, this resulted in a consent judgment, and it also sparked class action lawsuits by employees that resulted in more than $400 million in private settlements. So up until 2000, again, you're seeing these civil cases and consent decrees entered into, and the Justice Department was not viewing this type of conduct as criminal. Then we fast forward to 2016, when the Department of Justice issued HR guidance for human resources professionals. The purpose was to alert human resources professionals about potential antitrust violations in employment practices. But for the first time, notably, DOJ said that it would investigate and prosecute what we call naked no-poach agreements and wage fixing agreements criminally. No-poach agreements are agreements among competing firms not to solicit or hire each other's employees. And then wage fixing agreements are agreements among competing firms to set wages or other forms of compensation. So up until 2016, DOJ did not view this conduct as criminal. And then it issued this guidance suggesting that it would potentially investigate or prosecute it criminally. And I think from DOJ's perspective, they view this conduct, if it is what we call naked, there is no justification for it, that it is essentially a classic market allocation scheme and should be treated as cartel conduct. In 2018, the Department of Justice entered into another consent decree with 2 companies in the railway industry. Now that was a civil settlement and it did postdate the HR guidance, but as I understand it, the violations were uncovered before DOJ had issued this guidance, and therefore it was resolved civilly. It still did result in more than 15 follow-on civil suits by current and former employees, so it was certainly not a positive development for those companies who entered into the consent decree. And then now I'm going to focus on the most recent developments, which is that for the first time, starting in December, DOJ has brought criminal charges against companies and individuals for engaging in allegedly collusive employment practices. In December, DOJ brought its first criminal wage fixing case, and it charged a healthcare staffing company owner with colluding with competitors to set rates. The staffing company owner was a gentleman named Ndaa from Texas. He owns a therapist staffing company and was charged with allegedly conspiring with other staffing companies to lower the rates paid to physical therapists and physical therapist assistants in Texas. He was also separately charged with obstruction of justice for allegedly making false statements in a parallel investigation that was conducted by the Federal Trade Commission. So as a result of these charges, Ndaa faces 10 years in prison for the antitrust violations and then potentially another 5 more for the obstruction charges. No trial date has been set yet for Mr. Ndaa. It will be interesting to see whether he fights the charges and goes to trial. This is the first time that a criminal wage fixing case has gone forward. So it's a novel legal theory at this point, and we'll see what happens with that particular case. Then in January of this year, the Department of Justice brought its first criminal charges against a company, this time for entering into a no-poach agreement. This case also involved conduct in Texas. A Texas federal grand jury indicted a company called Surgical Care Affiliates for allegedly engaging in 2 separate conspiracies with healthcare providers not to solicit each other's senior level employees. So this company, SCA, and its co-conspirators allegedly participated in meetings in which they agreed not to recruit each other's senior level employees. They also allegedly instructed employees and recruiters not to solicit from each other, and then they ultimately allegedly refrained from soliciting from each other. In this particular case, trial is set for November of 2021. Again, remains to be seen whether the company will ultimately decide to enter into plea negotiations there. But also in January, it's interesting that the first class action was filed in Illinois federal court on behalf of senior level employees against SCA. And then just in February, a second class action was also filed. So those are the updates on the most recent no poach and wage fixing agreements. And just yesterday, I believe, there's another update on the issue of collusion in the labor market. There was a financial services tech firm called Incinco that stated in a securities filing that the Department of Justice was probing its employment practices. It disclosed that there was a grand jury subpoena issued to the company, as well as certain officers and employees, and that the company is cooperating in that investigation. So it does seem that the Department of Justice is focusing more on alleged collusion in the labor market, and in particular on employment practices. But again, because it's sort of a novel theory, it will be interesting to see if it gets tested in court. So I want to turn now to some other developments on the cartel front in other domestic investigations. And in particular, I want to talk about the ongoing ready-mix concrete investigation. In January, the Antitrust Division announced that it had entered into a deferred prosecution agreement with a company called Argos USA LLC, which is a concrete producer, related to an alleged conspiracy to fix prices, rig bids, and allocate markets for sales of ready-mix concrete. The alleged collusive conduct occurred in Georgia between 2010 and 2016. Under the deferred prosecution agreement, the company agreed to pay a $20 million fine and to cooperate in the investigation, as well as to adopt a compliance program to prevent and detect future antitrust violations. In return, the Antitrust Division agreed to defer prosecuting the criminal charges during the pendency of the DPA. It seems that DPAs have become more commonplace in resolving cartel cases these days, and that has occurred really since the Antitrust Division announced a change in its policy in July of 2019, permitting the division to resolve cases by DPA. The purpose is to incentivize corporate compliance. Traditionally, the Antitrust Division has viewed DPAs as potentially problematic and in conflict with its leniency program, which is unique to the division and grants leniency to companies who are first in the door to report misconduct and cooperate and comply with certain other requirements in the program. But we have seen more DPAs lately in resolutions of cartel cases, in particular in the generic drug investigation. I also wanted to report on some developments related to the Procurement Collusion Strike Force, if you're familiar with that. The Procurement Collusion Strike Force is a multi-agency task force that was created in November of 2019, and the purpose is to identify, investigate, and prosecute bid rigging in the government procurement process. And if you listen into a webinar that I gave with my colleague Alex Soria just a couple of months ago, we interviewed the new permanent director of this task force, Daniel Glad from the Department of Justice. So it seems like they are starting to treat this task force very seriously and want to make it a permanent entity that really does focus on collusion and bid rigging in the government procurement space. Most recently, in October of 2020, the Antitrust Division announced charges against a North Carolina engineering company, Contech Engineered Solutions, and a former executive of the company, for allegedly participating in a conspiracy to rig bids and defraud the North Carolina Department of Transportation. These charges were the first that were at least formally attributable to the PCSF since it was stood up in November of 2019. In its first year of operation, the PCSF has trained more than 500 federal, state, and local government agencies in detecting government procurement bid rigging, and that's resulted in the opening of several grand jury investigations. But until then, until this case was announced, it had not resulted in any criminal charges directly attributable to the strike force. The Antitrust Division also announced in October that it had expanded its partnership to an additional 11 agencies, including 9 US attorneys' offices. But at this point, other than that one criminal charge that's come out, it's unclear how much strength this task force is going to have. And it does seem like in the first year, the purpose of it and the goal was really to educate partners that it has with the various US attorneys' offices on government procurement bid rigging and to expand its partnership network. And then finally, I want to end on one final investigation in the cartel space, and that is related to the poultry sector. In October of 2020, a Colorado federal grand jury indicted 6 additional executives of broiler chicken companies for their alleged role in an alleged price fixing and bid rigging conspiracy to manipulate the price of chicken broilers. And in particular, broilers that are sold to fast food restaurants and distribution centers. The alleged conspiracy occurred over a 7-year period, and this investigation has gone on for some time and has been a big focus of the Antitrust Division over the past couple of years. The individuals who were indicted included the former president and CEO of Pilgrim's Pride, the sales director for Pilgrim's Pride, and a former sales executive for Tyson Food. The grand jury also charged the former Pilgrim's Pride sales director with obstruction of justice and making false statements as part of the investigation. We previously reported through our Executives at Risk newsletter that 4 executives of 2 major broiler chicken companies were indicted in June of 2020. And today there's a total of 10 individuals who have been charged in the investigation. In addition, in October 2020, Pilgrim's Pride announced that it would plead guilty to participating in the alleged conspiracy and agreed to pay a $110.5 million criminal fine. Just a couple of days ago, the company was formally sentenced, and the fine announced was slightly different. It was $107 million. Having looked at the docket, it's unclear why there is a discrepancy in the 2 amounts. But this investigation actually stems from a class action lawsuit that was filed in the Northern District of Illinois in 2016, in which the Department of Justice moved to intervene in June of 2019. And I would expect to see additional charges come out, at least of individuals in that investigation in the coming months. So with that, I'm going to turn it over to Katherine to talk a little bit more about poultry, but in the FCPA context.
Sticking with the poultry industry for a quick FCPA update. In October, the SEC announced a settlement with a Brazil-based holding company and its co-owner brothers, Josely and Wesley Batista, as well as global meat and protein producer JBS SA. The settlement resolved books and records and internal accounting controls violations of the FCPA. The Batistas each agreed to pay $550,000 in civil penalties for their participation in a bribery scheme connected to JBS's acquisition of Pilgrim's Pride, in which the brothers made approximately $150 million in bribe payments, partly derived from JBS operating accounts for the benefit of Brazilian foreign officials. And as part of the settlement, the Batistas have agreed to take enhanced FCPA and ethics trainings. So with that brief international update, I'll turn now to a discussion of ongoing domestic investigations, starting with the latest update in Wells Fargo. In January, the Office of the Comptroller of the Currency announced a settlement with the former general counsel of Wells Fargo, resulting in a cease and desist order and a $3.5 million civil penalty. And previously, the OCC had announced settlements with 3 other former executives from Wells Fargo's community bank. The settlements include, first, a prohibition order and $925,000 civil money penalty to the former community bank group finance officer. Second, a personal cease and desist order and $400,000 civil money penalty to the former head of Community Bank Deposit Products Group. And third, a personal cease and desist order and $350,000 civil money penalty to the former head of Community Bank Human Resources. The OCC found that these executives knew or should have known about Wells Fargo's systemic sales practices misconduct. And as part of the settlements, the executives agreed to cooperate with the OCC in any investigation, litigation, or administrative proceeding related to sales practices misconduct at the bank. And as we previously reported in Executives at Risk, in January 2020, the OCC charged 5 former Wells Fargo executives for their roles in sales practices misconduct and settled with 3 others, including the former CEO. So turning now to the UAW investigation. In September, the former president of the International United Auto Workers Union, Dennis Williams, pled guilty to conspiring to embezzle UAW dues money between 2010 and September 2019. The former president admitted that he had sought and received reimbursement for hundreds of thousands of dollars of personal expenditures, falsely claiming that they were business expenses. The expenditures included things like multi-month-long stays at private villas, cigars, golfing apparel, green fees, and meals and entertainment. And he is set to be sentenced in April. His guilty plea marked the 15th conviction in the government's criminal investigation into corruption within the union. And in November of last year, 2 other senior union members were sentenced to approximately 2.5 years in prison for accepting more than $250,000 in kickbacks from a UAW vendor in exchange for steering a $4 million contract to the vendor. And all of that happened. And then in December 2020, the union reached a settlement with the DOJ to resolve the extensive corruption probe into the union. Pursuant to the consent decree, which was issued by the court at the end of last month, a court-approved independent monitor and adjudications officer will be appointed to 6-year terms. The monitor's role will be to bring disciplinary charges or seek other dispute resolution to remove fraud, corruption, illegal behavior, dishonesty, and unethical practices from the union. And in turn, the adjudications officer will be empowered to impose discipline. Finally, turning to a series of domestic public corruption investigations. In October of last year, Jeffrey Longstreth, who had been a longtime political strategist for the former Speaker of the Ohio House of Representatives, Larry Householder, and Juan Cespedes, a lobbyist hired by an energy company to allegedly funnel money to Householder's enterprise, pled guilty to their roles in the alleged racketeering conspiracy. Sentencing dates have not been set for these folks. As set out in the federal indictment, which was unsealed last summer, Householder conspired with 4 strategists and lobbyists to pass and uphold a $1 billion nuclear plant bailout. The co-conspirators allegedly received $16 million through a 501c4 entity called Generation Now, which was controlled by the former speaker, with funds being dispersed to support political candidates as well as for the defendant's personal benefit. Some of the funds allegedly came from an Ohio-based public utility holding company, which was unnamed in the indictment, but which has been publicly reported to be First Energy Corp. And following the October guilty pleas, First Energy terminated its CEO, as well as 2 other executives coming out of an internal review. And just this month, Generation Now pled guilty to 1 count of participating in the conspiracy and agreed to forfeit its assets. Turning now to Illinois, in November, a federal grand jury indicted the former CEO of Commonwealth Edison Company, or ComEd, and 3 others for their roles in an alleged scheme to bribe the former Speaker of the Illinois House of Representatives, Michael Madigan, who just stepped down from his position in January. Interestingly, Madigan's successor in the House, Edward Guerra Kodat, stepped down just this week, 2 days into his term, after it was publicly reported that he vaguely had engaged in alleged questionable conduct. So the government charges the defendants in this matter arranged for jobs and contracts for the Illinois speaker's political allies and workers and created false documentation for payments in order to circumvent ComEd's internal controls. Interestingly, the defendants are now seeking information from the government regarding the grand jury procedures and the demographic data of grand juries during the pandemic. They're arguing that they need this information to determine whether their constitutional and statutory right to a grand jury drawn from a fair cross-section of the community has been violated during this pandemic time period. These indictments are coming on the heels of ComEd's July 2020 DPA with the DOJ, in which it agreed to pay a $200 million criminal penalty and engage in continuing remediation and cooperation with the government. And in addition, related to the ComEd investigation, this week, former Illinois Representative Eddie Acevedo, who in June stated publicly that federal authorities had interviewed him in connection with the ComEd investigation, was indicted on tax charges. Prosecutors have alleged that he failed to file an income tax return for 2016, 17, and 18. And one additional public corruption story coming out of Illinois broke this week. A Chicago political operative named Roberto Caldero was indicted in federal court for allegedly offering and providing bribes to City of Chicago officials, including an alderman and a public schools employee, on behalf of his clients in exchange for benefits, including a custodial services contract, as well as an honorary street name designation and the renaming of a park. So with that, I'll turn it over to Ian for some developments in financial crime enforcement.
Thank you, Catherine. And we wanted to just close with an update on some important developments in the financial crimes area. I will eventually talk about a couple of enforcement actions related to fraud and AML violations, but the biggest development in this area is the passage of the NDAA, the National Defense Authorization Act, which included significant changes to the AML laws and other enforcement laws, and will have an impact on corporate executives and financial crime investigations. So we wanted to start with just a brief overview of a couple of those aspects. First, I will talk about the beneficial ownership registry that will be developed through FinCEN, and specifically talk about risks for corporate executives. And then I wanted to highlight the changes in the DOJ and Treasury's subpoena power when it comes to foreign banks, which will also be an important tool for the prosecution of financial crimes going forward. Regarding the beneficial ownership registry, the NDA included the Corporate Transparency Act, and that will require companies to report to FinCEN the identity of their beneficial owners, which is someone who substantially controls the company or owns more than 25% of the company, with some exceptions. And the way it'll work is the reporting company will be responsible for reporting to FinCEN all of its beneficial owners, not the other way around. So beneficial owners are not going to be reporting their holdings. Who is a reporting company? A reporting company is defined broadly as any corporation, LLC, or similar entity created in the US or registered to do business in any state. And that is broad, but there's a ton of exceptions to that rule. And I won't walk through all of them, but just note that one example is that issuers are exempt from reporting beneficial ownership information, which is obviously a large exception, but if you just think about sort of the purpose of the statute, which is to identify owners for companies operating in the US, then it makes some sense. Regarding risks for corporate executives, obviously the reporting company is responsible for reporting the beneficial ownership information, but practically that reporting will be done by individuals at the company. And one risk we wanted to highlight is that the law makes it a criminal offense for individuals to willfully provide or attempt to provide false or fraudulent beneficial ownership information, or to willfully fail to report or update beneficial ownership information. And those violations carry penalties of up to 2 years in prison and fines as well. So the fact that the law contains criminal penalties, not just for reporting companies, but for individuals will be significant. And obviously companies and executives will eventually work to have processes in place to ensure that accurate information is presented to FinCEN. That said, all of this is still a little ways off. Treasury has 1 year to promulgate its regulations that govern how reporting will be done. And then after the regulations become effective, companies will have 2 years to report beneficial ownership information to FinCEN. So this is not right around the corner, but it's a big change in the law and worth thinking about and planning for. The second topic that we wanted to address from the Ndaa relates to subpoenas of foreign banks. Previously, subpoenas of foreign banks were limited to records relating to correspondent accounts in the United States, but the Ndaa includes provisions that expand that to allow US regulators at the DOJ and Treasury to issue subpoenas to any foreign bank that has a correspondent account in the United States. And they can issue those subpoenas for any records, including records related to foreign accounts and records maintained outside of the United States. If the banks fail to comply with the subpoena, the law also gives DOJ and Treasury some authority to impose significant consequences, not the personal criminal liability that we were discussing with the beneficial ownership registry, but still sanctions that'll have significant effect on the banks, including, for example, $50,000 a day for failure to comply, and the ability to force a correspondent US bank to terminate its relationship with a foreign bank that doesn't comply with the subpoena. So obviously those are big sanctions, and foreign banks will be working to consider their obligations, how to deal with these laws going forward. I think one thing is clear, that the ability of DOJ and Treasury to force foreign banks to provide information about foreign accounts will be substantially improved, and that will likely be an important tool for investigations of financial crimes as we move forward. And then I wanted to close with just some recent illustrative examples of insider trading, fraud, and money laundering enforcement actions that we've highlighted in our Executives at Risk newsletter this quarter. In August, the former CEO of Auspex Pharmaceuticals was charged by the DOJ and SEC with insider trading for allegedly tipping friends and family ahead of the company's $3.2 billion acquisition by Teva. The CEO allegedly passed material non-public information to several friends and family members who made somewhere between $300,000 and $700,000 on the tip, because the stock price for Auspex jumped by 70% immediately after the announcement of the acquisition. In addition to the insider trading, the indictment alleges that the CEO made false statements to FINRA during its insider trading investigation of Auspex Securities. Then in September of 2020, we had a sentencing of an 83-year-old businessman, Harold Vandergoltz, who got 4 years for tax evasion and money laundering related to concealment of significant assets overseas. Vandergoltz had pled guilty in February 2020 and was the first person to be convicted as a result of the Panama Papers data leak. The government, despite Vandergoltz being 83 years old, the government argued for a substantial sentence, noting that he lied about his foreign assets and tried to leave the country when he first met with government officials after the revelations of the Panama Papers. And in addition to Vandergolt's, his accountant also received a sentence of 3 years for helping with the concealment. And then lastly, in November of 2020, Panama extradited Gutenberg dos Santos to the United States to face federal charges for his alleged role in an international fraud and money laundering conspiracy. That conspiracy allegedly defrauded investors of a purported cryptocurrency company, Airbit Club. Dos Santos and the co-conspirators allegedly induced investors to invest $20 million in Airbit Club through cash and club memberships in return for a promise of guaranteed profits from cryptocurrency mining. Dos Santos allegedly hosted lavish presentations around the world to try to convince investors to purchase Airbit Club memberships, and he and his co-conspirators were arrested in August of 2020 before being extradited in November. So that's a summary of some of the developments in the financial crime space. I think that's all we have for today. So if there are not any questions, I hope this was an interesting way to spend your Friday lunch hour. And if you have any questions for us, you can reach out anytime.
Thanks, Ian. And we can also remind the audience, I forgot to say this at the beginning, but there is a Q&A function here where you can type a question into the chat and then we will be able to see it. So we'll just give it a minute here to see if anyone wants to ask a question right now. Okay, I'm not seeing anything come up, but as Ian said, you've got our contact information here. Please feel free to reach out. We've got a question from an expert in the white collar field who would like to know what areas of law do you expect the Biden administration to focus on? That's a tough question. Let me kind of answer from a cartel, criminal, antitrust space. I think in the antitrust space, it's a little bit difficult to say just simply with a change in administration and Democrats coming in that there will be more enforcement. But enforcement has been so low in the prior administration that it can only go up. I would say that there certainly will be a focus on the healthcare space, given the COVID-19 related work that is going on in the healthcare sector. You could potentially see investigations into healthcare related companies for allegedly colluding related to the pandemic response. So that would be my suggestion there in that space. If anyone, Ian or Katherine, want to add anything else on the Biden administration, please feel free to.
Yeah, I mean, I think I agree that the healthcare space in light of the pandemic is one that we're likely to see grow, especially with, regulations coming out around not only the medical space, but the funding programs that came out or may come out in the future in new packages, new relief packages. I think there'll likely be enforcement around that area as well. I think that a lot of the public statements of the administration right now in the justice field are really focused on the repercussions of the events of January 6th. And so a lot of the public statements really aren't focusing right now on the white collar space and are focusing on the domestic terrorism front.
Yep, I agree with all of that. And I know that the prosecutions in the related to PPP loans sort of started in the summer of last year, and I would expect that to be a focus of investigation as well going forward.
Okay, well, thank you both. I don't see any other questions. So with that, thank you everyone for attending, and please feel free to reach out to us individually if you have questions.
Have a great weekend, everyone.
Thank you.